not only are we looking for the remedy of money, we're also looking to stop their actions. And certainly there's been, because of the government has gotten somewhat involved now, and let's bear in mind the government's role in this. And through the Drug Enforcement Agency, there is reporting of all of these sales of drugs. And there's what they call an ARCOS database. And they know the volume of drugs that are being sold. Now, probably a lack of resources. I'm not trying to shift all of this to some DEA agent sitting in a 2x2 office. But the reality is that they don't have the resources always to follow up on this and to do what needs to be done or to really recognize the problem. And even when they did and they attempted to have prosecutions, they weren't effective. Only until this got in the face and this large litigation is filed did you have anyone's attention. Did people start recognizing that this is a problem that doesn't affect somebody down the street that I don't know. It affects me too. It affects everyone. Whoops. Okay, there's 3 basic wrongs, and I'm in a simplistic way as an overview. The manufacturers engaged in a false campaign to promote opioids for chronic pain. They said it was perfectly harmless to take these drugs for chronic pain. I mean, you know, you got a backache, take an Oxycontin. The risk of addiction is low. If you don't have an addictive personality, you're not going to get addicted. They talked about it as a psychological issue as opposed to also a medical issue, that there is a medical addiction associated with taking these types of drugs. They lied that this was the first treatment of choice. And it amazes me the number of healthcare professionals that they managed to convince of this false story. The manufacturers paid supposedly neutral organizations to distribute false information promoting opioids. They also, as I indicated earlier, failed to report suspicious orders. Why is this pharmacy in Michigan needing thousands of prescriptions constantly for the number of population? I mean, when you look at the population to opioid prescriptions that were sold in Michigan, that should have been a red flag to somebody a long time ago. What they did is they just acted like capitalists and they created a supply and a demand. They created all these, and then they created additional types of Schedule II drugs that are part of this crisis. You know, there also became pain clinic mills that would just pass these out basically to people. You know, when the primary doctor started getting, you know, the family doctor got a little bit suspicious, people started going to these pain clinic mills. And again, the number of drugs shipped there, the drug companies knew, the distributors knew that, besides ARCOS data, but the distributors knew, the drug companies knew that these were too many drugs. But that was their goal in the first place, was to sell all of these drugs. Okay, they use these front organizations. I love these names. They sound like they are so official and so impressive. You have the American Academy of Pain Medicine, the voice of pain medicine, physicians dedicated to relieving pain. That sounds like something that's really legitimate. Well, it's funded by these drug companies, and they paid for it. They fronted any of the research. They would put out publications through this without their names on it, of course. No one was aware of it at the time that they were, well, the people that were involved with accepting the money knew it, but I mean the general public certainly didn't know it. And they fronted through this the ability to sell the drugs, because they would say, this is the standard of care, physicians, this is what you're supposed to be doing. Your patient should not be suffering in pain. And if you're not giving them this prescription, then you are committing basically malpractice. So they created that atmosphere where they increased the selling of these drugs. And they also put out and published literature that would reach patients. You need to ask your physician for this. He should be giving you this if you have chronic pain. You know, you've also got on there the American Pain Foundation, a united voice of hope and power over pain. This one to me really sounds like the Federation of State Medical Boards. And it actually did consist of a lot of the medical boards in the various states responsible for licensing. I mean, that appalled me when I found out about that one. Because that means that, like the state licensing board, and I don't want to say Michigan did it because I don't know which ones participated in it at the time, but these various boards, licensing, protecting the public, were participating in this scam. You know, the Joint Commission, another one that sounds. This American Pain Foundation, they published a newsletter. And in it they said there was a tragic consequence to leave many people with severe pain undertreated because they or their doctors fear that opioids will cause addiction. 90% of its $5 million in funding in 2010 came from the drug and medical device injury, including from at least 5 of the defendants in this case. It received more than $10 million from opioid manufacturers from 2007 to 2012. They also directed these fronting groups to deceptively promote opioid use to the various legitimate medical organizations. And they provided funding to those professional associations as well. They also paid what you call key opinion leaders. You know, people who write articles, they get themselves out in the community and they all of a sudden become a self-appointed expert. And all of a sudden they've written 10 journal articles and everyone believes them. They paid for those articles in many, many of the instances that resulted in the overselling of these drugs. Okay, well, this is an example of a brochure, a policymaker's guide to understanding pain and its management. Again, sounds like something you might pick up in your doctor's office. I mean, you know, you've gone in your doctor's office and you see these brochures. The American Pain Foundation, Treatment Options, a guide for people living with pain. This American Academy of Pain Medication, which again sounds like an official board of the American Medical Association, they introduced what they called pain is the fifth vital sign. In other words, they gave it a name that made it have medical significance. And basically they foisted it on these primary care doctors who maybe weren't as educated in pain management. So they also got the U.S. Department of Veteran Affairs to adapt the campaign as part of their national pain management strategy. So in other words, the government was also bamboozled by them. They issued guidelines in 2009 recommending opioids as safe for patients who had past abuse histories. And these guidelines became like a Bible to these practitioners. I mean, they had a very large impact. And they kept telling people that the risk of addiction was very low. They participated, you know, when doctors have to go to continuing medical education, they paid for those seminars and for speakers at those seminars to spread their propaganda, again without their names on it, so no one knew that they were doing it. They published literature in these recognized journals that were absolute lies about the addictive quality of these drugs. Okay, I mentioned earlier, the Controlled Substances Act requires these manufacturers and drug companies, and it's a combination of the Act and some legal cases that were decided along the way, that they have to design and operate a system to detect and report suspicious orders for controlled substances. Well, they sure weren't doing that here, and that's one of the violations. Now, there's not a monetary payment for violating this. They can be assessed fines by the federal government for violating this, but in the legal cases, it is an important fact that they violated it, and because they did, then it created what we call for those that are law students, they'll understand different causes of action, and it's an important fact for those causes of action. In other words, you can pursue a nuisance claim because of the violation of the statute. And they also fail to report suspicious orders, which includes, they're supposed to halt it. If it looks suspicious, they're supposed to stop and not send that order. No one was stopping sending orders. And that provision is also in the Michigan Act. I hope, I've probably been going a little bit too long. Well, I'll try and wrap it up with the litigation real quick. The manufacturing defendants are Purdue, Janssen, you know, you can see some of these names. And then you have the wholesaler distributor defendants. And they manufacture, but then it gets into the stream through the distributors. But a lot of these distributors are tied into these manufacturers. These defendants are among the biggest corporations in the world, most profitable. They're like fourth, fifth on Fortune 500. Some of them are top earning companies. One of these companies is second highest earnings in revenue in the country. In 2011, pharmaceutical companies generated revenues of $11 billion from opioid sales. And if you look at this is all the different sectors, and pharmaceuticals are right up there with banks in terms of how much money they're making. Now, with all that money they're making, you'd think that they could do some research and science. But if you look at this chart, it shows that research and development is half of what they spend on marketing and sales. Which usually, if people need drugs and you've got a scientific community to sell it to, the physicians, you shouldn't need to do all that marketing and sales. That in itself is telling. Now, Michigan, our claims, we filed in federal court. Michigan law is not a particularly friendly plaintiff state, and it has a lot of issues with statutes of limitation. We don't have what they call a discovery rule. It has a lot of limitations on recovery. We have a Products Liability Act that says if the FDA approved a particular drug, that you can't sue for that drug unless that they misrepresented something to the FDA. The argument here is that they did represent something because they misrepresented the purpose that they were using it for. They weren't using it for cancer patients. They weren't using it for the short-term treatment. They were using it for just chronic pain. But because of that, we filed also a RICO claim, which is a racketeering claim. You hear of that most often in the criminal context. In the civil context, those cases are often not successful. We believe that it will be successful here. Thus far, any rulings in the Ohio court have been favorable on the RICO claim. You know, that's not dispositive. It's only right now saying you've created a question of fact that your claims are under RICO. We also filed a claim under the Michigan Consumer Protection Act saying that they violated the deceptive advertising. I don't know which one I'm out. Deceptive advertising provisions of that act. And again, you know, the actions are the same. The act of promoting and marketing the use of opioids for improper purposes, circulating false and misleading information, and downplaying or omitting the risk of opioid addiction. Probably one of the strongest claims in this lawsuit is public nuisance. And it sounds odd to think of drug addiction in the context of public nuisance. But if someone unreasonably interferes with the right of that is common to the general public, and that interferes with your public health, safety, peace, comfort, and convenience, you have a possible claim. And they also engaged in conduct that was prohibited by statute, that federal statute that we were talking about a moment ago. And it has created a long-lasting effect. We also made a cause of action for negligence. Again, all of the actions give rise to these different types of cause of action. And you have different proofs for them, but you are still, your factual proofs are the same. And then we also have a claim for unjust enrichment and fraud and civil conspiracy, which we don't have a chart for. Some of the, okay, this case, what happens is people file these cases, and when there's so many of them, under federal law, they have a right, just for the federal cases, to go before this judicial panel, and they consist of 9 judges from around the country who are appointed by the Supreme Court, and they decide maybe this case needs to be handled in front of one judge. And because you can't have all these judges all over the country handling all this litigation. And the goal is you get it in front of one judge, you share the discovery in these cases. Maybe you do what they call bellwethers, where they select certain cases and they allow those cases to be the model for what's going forward. And that's what they did here. They sent it to Ohio, to Judge Polster. What he did first, he created a bellwether of 2 Ohio counties and the city of Cleveland. Ultimately, he moved the city of Cleveland out of the bellwether, and that was going to be the first trial. And he did briefing on that, what they call motions to dismiss, challenging, there's no such claims as these type of claims, that you can't prove that we caused the opioid problem. And also saying, well, you know, the people who took the drugs, it's their fault. The judge denied all those motions, and those claims survived. He also created a second bellwether, and he said these other states can also be briefed. And Michigan was one of the only 3 other states that was briefed. And he hasn't decided the cases in Michigan yet, but Michigan, the Monroe County complaint that we're pursuing is the bellwether for that, and which will impact the Oakland County case and the Wayne case.